Hey guys, it is Artie of Artie's Corporate Fiction. Welcome to what is it Thursday? Yeah, it's Thursday. So it was a long day today. I actually wanted to join in with Natalie. I know she is either still in the live stream with Mike, or it ended, or still going. Either way, I really wanted to actually join them, but I couldn't. I had just had a really long day at work. So I do know that some very interesting things happened today in this Darrell Brooks trial. So yeah, I guess we're gonna find out. I'm going to try and see if I can get through these as fast as I can. I don't want to be on for too long because I still have a lot of tasks to do before heading out to see Danny and see the family for the long weekend. So want to get everything squared away, but I want to say hi to everybody. Thank you for joining me, and we're going to start right off with what else the morning, where he as usual, you kind of expect this to happen. So
subject matter jurisdiction.
With subject matter jurisdiction,
that is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
for the record, is this the which you're referring to? This
the page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I set for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that's
I wanted
relevant.
to make the record clear. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record and should be addressed.
It does not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet to be proven on the record.
I'm not going to go down this path today. I'm just advising you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has filed
should be proven
a
for the
motion.
record by the prosecution.
The objection is noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right, I'm going to turn to Attorney Opper. I believe they filed a motion
Jesus.
this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night.
Probably, Omega.
All right, go ahead. You can make.
I didn't look at the document.
Whose fault is that?
Set for value, return for value, the document. I didn't look at it.
So then what? Do you think? Then okay.
I don't know what I'm supposed to say to that.
All right, well, Attorney Opper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes. First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been that topic.
Get with anything for the $5. We'll get to that.
For it to change, I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't.
So basically, you're saying it's okay. If you're saying it has no bearing on the charges, then there's no issue.
Emotion needs to be heard about one word. Is
yeah, they're changing. It's the information.
Kind of a moot point. It's been charged like this for a year, basically. The language hasn't.
They're giving you the opportunity to hear on a change of a material document.
So what is the significance of this now at this point?
Angstball, thank you for the 10 gifted memberships.
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd 1, and State versus Gerard, 189, a Court of Appeals case. Also point the parties to State versus Frick. Hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will file that document.
So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
Well, what happens if that happens?
She just said she's not going to answer the question.
Advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that then.
Makes no sense.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as indicated yesterday.
Casey did tell the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury on the different parade.
All right, so now we're going to skip ahead to this Detective Casey, and probably one of the more, explosive, bombastic parts is that in part of the testimony, they show a still image from Brooks's music video.
Do you have any reason to believe that the video was altered or?
And I'm going to
Do you
skip.
know if anyone's in the vehicle at the time that you see it pull away? Viewed this video, as you call it?
I don't believe that was my testimony.
All right, I think you're at the part.
Who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Regarding the use of the vehicle?
At the time of the incident? And what information was that?
Hold on. I'm trying to find where.
Done with the exhibit, sir?
No, I'm not.
All right, thank you.
Exhibit came from, correct?
Here we go.
I testify that this came from the entire video.
What? What? Uh-oh. Now I'm getting Comcasted? I need a new ISP. All right, I'm going to say 14209 is a timestamp just in case.
During the stream, I don't think it's you.
So you're withdrawing your question?
Yeah.
Entire video, correct.
You
There we
said
go.
that you viewed the video in its entirety, correct?
The entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Oh, it was
You
a
see
stream?
The video in its entirety.
Oh,
The
okay.
video that this exhibit came from.
yes.
And are these the only two individuals that you observed in that video?
Okay. I was hoping they were going to show it again, but yeah, this is the still image that they have been talking about this whole time.
They are the only two that I recall seeing in the video.
Did you?
Obviously, the one of the more important aspects is the license plate number that matches the same color Ford Escape, and he also testified that the individual with his back turned to the camera is Mr. Brooks, but he testified that he knows that because he saw the whole video. The problem is that Brooks is grilling him on the identity of the individual there, and it's going to come back to bite him in the ass.
Did you ever inquire about the identity of this individual?
No, I have not.
What? Throwing his friend under the bus.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to exhibit 13.
All right, I'm gonna skip ahead now to so now that we know the setup for the redirect, but I'm gonna skip ahead to around here where Danny said that there was a moment in the questioning, and I'll just let it play out. But she told me what it is, but I thought this was the way I thought this was interesting when she described it to me.
To this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Typical claim
Consider
filing.
yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. And I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it would be fair to say you don't know for sure.
That was my testimony.
I said what I said.
Is that the answer?
Yes.
Investigator,
There we go.
as lead investigator for this matter, where are you, to your knowledge, aware of any GoFundMe type of things?
Objection relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Sure.
Yes, I think there are.
Extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
What?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
Yeah.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it. Extremely.
Wait, what?
I'll answer yes if that helps.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Objection.
Yes, it's very typical. It happens in
I would object
most
relevance.
larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in the investigation that sits with the prosecution.
Talking about this case or any case?
This particular
or-
case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective
I feel like he's doing
actively
it on
involved
purpose
in
to get under his
this
skin.
investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not
Substain. Yeah, now I
In the
can't.
courtroom, the
Definitely
whole
can't
trial is not
unhear it.
relevant.
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known.
They're all against me.
Nobody
It's
sitting at
not
that back
relevant to
table. I
the
don't even have
issues
a
that the
back
jury
table.
needs to determine. Next question, sir.
Is it asking? We're telling.
Okay. I really
I'm assuming that's asking.
hate that he's says that kind of shit and is not.
You know what the other one would entail.
See, what the fuck is that supposed? How is that not a threat, or at least characterized as a threat? God damn.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will.
Sorry. Danny said I talked over the best part. Let me go back.
Mr. Brooks, next question.
Off grounds.
Sustained
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. Is not relevant.
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody sitting
It's
at
not
that back
relevant to
table. I
the
don't even have
issues
a
that
back
the jury
table.
needs to determine. Next question, sir.
Is it asking? We're telling. I'm assuming that's asking. You know what the other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will. So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection,
You
move
are
to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
They always are.
All right, thank you. Be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
She's allowed to stop it.
I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this witness.
They're going to keep coming up.
And I determined at that time that they weren't relevant. So next topic. Please.
Honestly.
Under 906.11, sir, please move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will bring it to an end.
You don't got to keep doing that, Your Honor. You don't got to keep doing that.
He's getting freaking agitated. Like I sometimes I don't like to just boil it down to what it really is, what we all can see, but sometimes, what you see is what you get. He really does not like it when a woman tells him what to do.
Responsibility, sir, over this trial.
I'm informed.
Thank you.
And I respect that. But it's relevant for the jury to know the truth. They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard those last statements. They're not relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
not truthful.
All right, under 906.11, I am now stopping the cross-examination. Any redirect by the state?
Objection to that. And I would like
Noted.
a legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so.
And here you go.
Under
I'm
advisement.
objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir. So let me see it, and I'll take your objection under. I'll take the objection under advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead, Attorney
I have
Opper.
all the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it. Oh man.
Thank you, Z360, for the 99-cent super sticker.
Stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness.
That's not leading.
I'm still going to object. How's this?
Mr. Brooks, I ask that you honor
I have all
the ruling that I've been
all the
made.
exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made?
Mr. Schuckler,
I'll
thank you for the
take that outside
$2.
the presence of the jury, but I'm going to allow
Can
it.
that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence.
Can you explain what's going on? I'm not an attorney. Well,
and the state may
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted, it's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mind-boggling.
Ford Escape. This is the video in which that still photo was taken from.
Objection, how does he know that?
Does he know?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection, leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll find that
Still
it's
don't know how
relevant.
it's
I'll
obtained.
receive Exhibit 168. Permission to publish is granted. For the record,
It's 178, Your Honor.
178.
please tell me the length of the video.
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that's not, that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
So
It's
mad.
noted,
This is
it's
mind-boggling.
overruled.
Mind-boggling.
Isn't it?
actually, Your Honor, I changed my mind. I would like to play the audio, please.
And we find all right, for the record, I did watch it. Oh, I do know what happens here, and I do know what the prosecutor says later on, but I do love the fact that she decided I want to change my mind and play with the audio. Fuck this guy. Thank you, commentator auditor, for the $10 super chat.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? He's just setting the foundation.
It's relevant. You
Math
question
boy
the officer
fly.
You question
Half a
the detective
ticket.
About
I
his
question him
knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received.
I like how he only had. Wait, hold on. I want to see what.
The video wasn't even in the exhibits that I received.
My dude is so hung up. He can only afford one fake $100 bill for his music video. Damn.
I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
And using his mom's Ford Escape as a backdrop. Oh my God. I wonder how much he paid the dude on Fiverr for these edits.
So play the sound. I want to hear it now.
Oh, I missed that part. I actually missed him say that. What the fuck?
I'll address that later.
Another example of how this guy just thinks this is all a game. Like, he doesn't even understand. Yeah.
We address why it was created out of the Bluetooth.
True, free publicity. Standard narcissism explains it. I'm pretty sure I did a better job of making a music video when I was in high school. My AV class. And that was terrible.
Proof where it didn't happen.
Go ahead, attorney, after the video is finished playing.
No, it's
That you,
it's
sir,
lost to the
did you
ether.
see during the playing of that video, the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175.
Objection leading.
Overruled, foundational, the witness may answer.
Yes, I
A
did.
lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Copper.
Overruled, the
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled, the witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
No, and that's all it took. Thank you, Tony, for the $20. Do you think you would be this argumentative with a male judge? I don't think so. I don't think so.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted.
I
Do you have any questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That
Sustained.
was a question. A question. When
Sustained,
was this
as to the
video
form
made
of
an
the
exhibit?
question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under
Oh,
my
he
breath that was
mad.
disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please,
and
and
faces.
admonish him?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All
Big
these
man.
witnesses in here, don't nobody
However,
ever see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained
it was
as to the
not
form
brought
of
up
the
in
question,
the
assumes
testimony.
facts not in evidence.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked or however you refer to it, what would be the need to view again this morning something that you had viewed numerous times before?
I'll see what my
Objection, objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
All the objections. Here's the problem that he doesn't like is that, and they'll tell him later on, he opened the door. He questioned the detective's knowledge of who the person was in the still image. He testified that he knew who it was because he saw the video. But Brooks kept on going after him, questioning his credibility and his ability to make the identification. So in turn, the prosecutor, probably also pissed off of his bullshit, decided to troll him a little bit and get a copy of the actual video, bring it up, and put it into evidence to rebut the cross-examination. And he's mad. He doesn't even realize that he is the cause of his own fuck up.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts, not in evidence.
Sustained. As to the form of the question.
This is mind-boggling.
Mind-boggling.
It's mind-boggling.
Mind-boggling.
Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're going to sustain everything?
It was already
Probably.
answered, sir. Next question, please.
Are you going to
I
object
asked
to
for
everything?
Clarification.
Next question, please.
I don't got no more questions, man.
All right. Thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason. Because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You people? What do you mean, you
Have a
people?
seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection. I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need to
something that
make
I
a
saw?
record. So just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
No.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then?
No.
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Yeah.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video. Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based
Hold-
upon what
wait,
I
what,
viewed in
what?
that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a
Especially when you stated in the middle of the video that, hey, man, now I want to hear the sound. Suggesting that you may actually know what it's about. Dude. He's so mad. I love it. Real quick. I'm sorry, guys. Kit, 190, thank you for the $5. Is the fact that there's a sub-stained lead to the possibility of dom stained. God damn it, Kit. And Holden, nice name. Holden, thank you for the $4.99 super chat. Make 1,000 objections, and eventually one will be sustained. Even a blind bird gets a worm every once in a while. No, I exactly. You know, broken clock, you know, is right twice a day, all that jazz.
It's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course,
exactly.
It's ultimately up to the jury to determine that, and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that.
What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was, how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that, because obviously they marked it as an exhibit.
But with all respect, Your Honor, you're mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit? That was the issue.
Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media.
Nothing
he didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Make the record
interrupted multiple times. I've been abundantly patient with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me.
To be quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and I've made note
I'm
of it.
looking at you. Okay, so are you asking me to be quiet, or are you telling me to be quiet?
Here we go.
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
and
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him to sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up.
Yep.
And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception.
Thank you. Basically saying everything, probably everything many people who have been watching this trial have been wanting to say for the longest time. I know plenty of people, including myself, have been frustrated with the judge and the level of tolerance she's had with his absolute disrespect, the back talk, the insults, the muttering, down to the muttered threat that we heard earlier today. We've been frustrated, and I myself included, where a lot of us feel like she needs to do something, but I also understand that she's in a tough position. She's not in an easy position to be in to try and navigate through this trial and dealing with somebody like Brooks. But I do appreciate that the prosecutor, at the very least, said what everybody has been wanting to say for like the last 2 weeks. So
I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that
Audacity.
when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't
There
know
was a reference made
specifically
to
what you're talking
there's a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's
exhibit.
been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I
for her to sit there-
haven't made any of those.
I didn't
Sir,
say
what
you.
I've
I didn't
observed-
say you, Your Honor.
No, no,
But
what I've
for
observed
her-
is
for
I'm not an idiot.
Listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me.
Thank you, trans girl,
she
for
must
the
think
17 months.
Nobody
That is
said
very
sir.
disrespectful to me. I haven't seen
Oh, poor fucking you've been disrespectful to the judge this entire endeavor. So keep crying.
anything about that until today. She's done it numerous times.
What are you talking about? I don't know
Her
what you're
laughing
saying.
under her breath. Her trying to cover up the microphone so they can laugh and hee and key. But they've been doing that the whole time.
My God.
I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I
involved
haven't
with
noticed that other than the one thing you pointed out.
Well, we
today,
have
which then-
cameras. That's
Okay.
what the cameras are for.
Let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
Big
take
mad.
If
that-
you have
I
anything you
take
want to
that
put on
as-
the record,
I'm putting it on the record
as
if I
it
get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not. She just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of any.
need legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is
She already said one that it was already provided to him in discovery to his attorneys, his former attorneys. So if you don't look through your boxes, that's on you. Number one. Number two, she already stated that if it's relevant, she can turn the evidence that she already provided into an exhibit. So it sounds like they weren't necessarily planning on using the video in the first place, but they wanted to say, let's turn it into an exhibit and present it. But he opened the door, and he doesn't like the fact, and he doesn't like it.
is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying
exhibit.
that she could
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of
During-
speech.
Okay, so what is
Alright.
it implying to? What would that be implying to?
As attorney,
How would anyone-
all right,
how would
I'm
anyone in
moving
my
on
position-
because you're not providing
How
me
would-
with any
how would
legal
any-
basis.
I didn't even finish.
For me to,
You told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything?
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how
you're
do you-
rant,
how do you know I
you're
wouldn't get to
providing
that if I
commentary,
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
Yeah. That's what being an attorney is for. That's what being an attorney is all about. A good trial attorney is a skilled attorney is able to do that.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was
Skill issue. Get good.
supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're
absolutely
talking about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your Honor,
you in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come at
not,
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it relates
asking
to
me
other
to do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you.
See how he fucking reacts like a fucking toddler. Well, I'm not doing anything.
Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer it
if I don't
correctly,
understand,
then I
if
will
I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I don't
a
like
yes or
I don't
no.
like your tone and the way you're talking to me.
See, another example. How dare a woman take tone with him?
Mr.
I don't
Brooks?
appreciate it.
Sit down.
Or in
I
his
don't
case,
care if you don't like my
females.
buttons. You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm trying to understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to
everyone.
answer if I don't understand? And I don't agree to a stop.
They cut off the mic. Okay, we're gonna move ahead.
Some issues outside the presence of the
Was referenced as 165 or 178 was
to eat and come back fresh.
Okay, that they go to lunch. All right, I am not going to play his opening, because if I do, it's just gonna get me pissed, like really pissed. I'm only going to play some very brief moments in it, like maybe a minute's worth.
Has yet to be proven for the record.
The jury will disregard the incorrect statements of the law that Mr. Brooks is stating.
Where's lawful law that is incorrect?
Mr. Brooks, please.
Oh, I'm glad I made it to that part where he says lawful law.
I am going to read one instruction. Thank you, everyone. Please be seated.
What's the lawful law?
Make an opening statement. The purpose of an opening statement is to give the defendant an opportunity to tell you what he expects the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
Obviously, I don't have any rehearsed or well prepared speech, so I'm just going to speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year, there's only truly been one side told of this story. And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, and finally everyone getting a chance to get the full story. You won't hear me try to argue facts. The fact is that this incident was tragic, very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing on both sides. And when I'm confident that the evidence will show, sorry, I'm getting a little emotional.
And we're done. I'm stopping at that point. Fuck this guy. He then proceeds to do a long pause and then starts the waterworks, yada yada yada, talking about mean comments, blah 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 blah. He can go fuck himself. I'm not gonna subject the rest of you guys to that. So yeah, we're gonna skip right ahead. So you could see the clips then if you want to see it, where he has the waterworks and he's crying. Assuming even if those are actual tears, they're only for himself. But yeah, he does a whole fucking sob story for an opening statement, and then this is what happens when he calls his first witness.
Have you found what you were looking for?
I'm just gonna go with. I'm just gonna work off the list of the people who's here,
Okay.
if that's fine.
All right. You know who you're going to call first? We'll have that person ready.
Yeah.
Okay. You want to let us know so that the state can assist with that? Otherwise, you can just call when we are in front of the jury. So have the jury brought out, please.
Some of them are downstairs and some of them are out here. So it's fine. It just will take a few minutes if they're over in the main courthouse.
Okay. Why don't you tell the state the first witness to make sure they're right outside the courtroom, sir?
Most likely Bertram.
Okay.
Most likely.
Do you want to give us two names and we'll have two people out there? I just want to make it go smoothly, sir, that's all.
Since I'm working off this list, I wasn't expecting that to be first.
Who do you want to call first? And we'll see if they're here.
Well, sorry.
That's okay.
Apparently, this list is who's here, I'm guessing.
That's my understanding as well. Not yet. Is there someone you expected to be on the list that is not?
Kinda.
Looking back at this again in hindsight, now I see exactly what he's trying to do, and it's just making me even more furious.
Do you want to make a record of that? Do you want me to address it in any way?
No, not right now.
All right, well then I'm going to instruct the jury to come out, and then you can call your first witness. You can have this back again.
I'll get to the other super chats later, guys. Promise, that I haven't seen yet.
All rise.
Right back.
Thank you, everyone. Please be seated. All right, you may call your first witness. Actually, your second witness.
The defense would like to call the plaintiff, state of Wisconsin, to the stand.
Bruh.
So all of that in the opening statement, all of that crying, all of that whining, he still has the chutzpah to pull that in front of the jury, to still go on this sovereign citizen bullshit. Oh my God.
Object. The objection is noted. It's sustained. Call your next witness, please.
Reason for the sustain?
Not relevant. And you haven't named a person to go along with it.
The subpoena was accepted, Your Honor.
I'll take the issue up outside the presence of the jury if necessary. Call your next witness, please.
Well, I would like to make an oral tennis motion to dismiss for failure to appear by the plaintiff.
Oh, shut the fuck up!
Relief can be granted.
I will take that up outside the presence of the jury. Next witness, please.
So is the state not present?
Mr.
God.
Brooks, I'm not going to address that any further while the jury's present. I'll take that up outside their presence. Call your next witness, please.
The defense calls Nicholas Kirby.
All right. Nicholas Kirby.
So it's already at 8:15. My understanding is with this witness, yeah, I know, an oral motion to dismiss. The thing is that at the point where at the point where the state rested, he could have he could have actually requested a motion to dismiss the case because the prosecutor, failed to provide evidence of all the elements of the charges. I mean, if that actually happened and he had competent attorneys, they could have theoretically requested a motion on that basis the moment the state rested, because it's all up on them. But obviously, that's not what's happening here. He's a fucking idiot, shitbag.
Is that a witness who's in the hallway? Do we know?
I don't believe in the hallway, but we will.
Have him brought over, Your Honor.
I don't want to go through this. Suffice to say, guys, the witness here is, I believe, is the man who was in the video. There was a friend of his ex, and I think he was in the video when they had the initial altercation. He, of course, he as in Brooks is a complete moron. The guy does not like Brooks, so of course his testimony, while biased, is completely damaging to him. But he still has him on the stand anyway.
While we wait for that witness to come into the courtroom. To the remain.
You so help you God?
Yes, ma'am.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record, and then to spell each. Go ahead.
First name.
Janelle just super chatted with 199.99. They said sorry, I had to. I thought we could all use a laugh after that bull hockey.
Wow, thank you, Janelle, for the $199.99 super chat and ruining my ears. Thank you so much, Janelle.
NICHOLASKIRBY.
Right, thank you. Go ahead, sir, your witness.
Good afternoon, Mr. Kirby. How are you today?
I'm here.
What do you do for a living?
Mostly temp work.
Do you recall the events of November 21st of 2021?
All too well.
And what were you doing that day?
What time of the day?
Around 3 o'clock-ish.
3 o'clock-ish. Around 3 o'clock-ish, I was walking with Corey around Waukesha. Earlier, well, yeah.
And made reference to walking with Corey. Who is Corey?
Corey is a friend of Miss Patterson's.
And would it be fair to say that it's also a friend of yours?
Mutual friend, yes.
In reference to Corey?
Yes.
Oh. And what were you doing?
Walking around Waukesha. She was waiting for Miss Patterson to get done meeting with Mr. Brooks. You.
At 3 o'clock?
Around 3 o'clock-ish. Around that time, I had advised her not to go meet with Mr. Brooks.
You made reference to Mr. Brooks. Who's that?
Hey, corrections, can you get me a timestamp for that? I did see that part.
Why would you say it would be
you? That's you.
Because that's your name.
And you were privy to that information at the time?
I was privy to the information about you about a week prior to this incident.
About a week prior. And during your walking around, what were you doing with Corey?
Walking, like literally walking. We went from one store to walking around downtown after Erica told us she was going to be going to meet with Mr. Brooks. That would be you. I had advised her not to do it because it was a bad idea, and I was in fear for her safety.
You made reference to going from one store to another. What stores are you referencing?
Dollar General and Speedway.
Did you go anywhere else?
No.
Did you ever go to a park?
No.
Yeah, like I said, you don't. Like I said before, you don't need to be a body language
to knowing about
expert to know that this guy fucking hates Brooks.
Brooks a week prior to these events, you said?
I didn't know everything about him. Miss Patterson had showed me his rap sheet, if you will, and a picture of him, and that was about it. I had heard prior.
I'm going to stop the witness unless you want him to go there, not to discuss what may or may not be conduct of Mr. Brooks prior to November 21 of 2021.
Okay.
With that understanding, go ahead and ask the next question.
The interview he did after his testimony.
You made reference to a picture you...
Can you share a link in that Discord?
Just a photograph with a rap sheet behind it.
And at some point, did you and your mutual friend Corey meet up with Miss Patterson?
Yes.
Do you recall where that was?
Corey and I were in the Dollar General area of Waukesha, which is between East and Broadway Street. We were walking towards, or away from Dollar General, towards where Erica had said that she was being assaulted and attacked.
And do you recall where that area was?
Yes.
Where was that area?
On White Rock Avenue, right across from White Rock Elementary, in front of the red apartments across from that area.
Red apartments?
Yes.
Do you know what those apartments are called?
I do not know the name. I'm guessing they're called White Rock Apartments.
And do you know if there's a park in that immediate vicinity?
There is a park there named Frame Park, yes.
Did you ever go to Frame Park?
No. We were in that area near the park where the elementary school is and the apartments are.
About what time did you and your mutual friend Corey meet up with Miss Patterson?
Miss Patterson called me and said that she was...
About what time was the question? About what time?
I'm getting to that.
I'll direct the witness answer his question specifically. What time?
Honestly, around what time the parade started. I would have to say like dusk. I honestly don't wear a watch, so sorry, I don't remember the time. But if I had to put it at a time, I'd probably say about 4:35-ish.
Let's back up a little bit. Around what time did you and your mutual friend Corey first hook up that day?
I had worked that whole day, so we didn't meet up until I was done working, which was probably about 2:30, 3 o'clock.
And at some point, you received a phone call from Miss Patterson?
Yes.
You yourself?
Yes.
And then at that point, what did you do?
When she told me that she was in trouble and she needed help, I went to her aid, which means I took off from where I was near Dollar General and ran to where she told me to go.
And when you got there, what did you see?
When I got there, well, halfway towards White Rock Elementary, I stopped a police officer at a barricade and I let him know that a woman was being assaulted in a vehicle.
And do you recall giving a description of who may have been assaulting your friend?
No.
Why not?
Because at that point in time, the description didn't matter. I had the identity of the vehicle. So I told them, you need to be looking for a red SUV with a woman screaming out of it.
And how did you come into the knowledge of the description of the vehicle?
Because I saw the vehicle.
At what point did you see the vehicle?
When Corey and I were
there it
walking
is.
up White Rock Avenue on the apartment building side of White Rock.
All right, thank you. Corrections. We're going to skip ahead to 6:47. And then from there, I'm just going to close up shop.
Detective, do you yourself recall stating that the alleged defendant tried to punch and push you?
The alleged defendant being you? Yes. Attempted to.
Would it be fair to say from the video that it doesn't show you being pushed or?
No, it does not. It shows me pulling two women away from the situation.
Any reason why you would state to detectives that the alleged defendant attempted to punch and push you?
Probably because there were three different people's fists flying, and I was just trying to get the people that I cared about out of the way of danger. So if my statement to the detective is off a little bit after watching a bunch of people get run over, I can understand why.
Fuck.
So you were at the parade that day?
Jesus, this guy is savage.
I was not at the parade that day. I was in the area.
So
trying to get back to my house.
So how can you watch people being run over if you weren't at the parade that day?
I wasn't attending the parade. I was in the area that the parade route was in. My street is the parade route.
Fuckface.
Did you see anyone injured that day?
During
the parade?
Yes, after I walked back through that area.
You saw someone get injured?
I saw a red SUV take off like a bat out of hell down Main Street and go through a crowd of people.
The question was, did you see this take place?
With my own freaking eyes, yes. How many times do I have to say yes for you to understand it? YES spells yes.
I'm sorry, Your Honor, I don't know.
Well, so you moving to start the last response?
Yeah.
The jury will disregard the last response. I'm just going to remind both of you, please answer the questions that are asked. And follow-up needs to take place. Either Mr. Brooks or the state will ask.
Is it fair to, well, in reference to the Exhibit 3 video that we just viewed?
You're talking about the one by the elementary school?
Yeah, the one
Okay.
the one that we just viewed,
Just checking.
which would be Exhibit 3. Is it fair to say from that vehicle, got me?
Video.
I'm sorry. From that video, is it fair to say from that video that, in fact, there are not three people throwing punches? Would that be fair to say?
There are three people throwing hands in that video. Erica, Corey, and Mr. Brooks.
Honestly, I don't know why he's, well, we kind of know why. He's so insistent on talking about the DV situation and not about the actual the meat of the case, which is him running over 60 plus people and killing 6. But he's so zeroed in on the actions surrounding the DV incident beforehand. It's amazing.
Not myself.
And
oh wait, there we go. I will wait for the for them to say.
No further questions.
before I decide whether to do cross at this time, how long do you believe it will be?
0 minutes because I have no cross.
All right, thank you.
No need.
Take a break.
All right. The other witness he brings in, I think, believe it's some guy who said he was called up just to say that he may have heard of horn sounding. That's what Danny was telling me. So I didn't hear or watch any of the testimony from this other witness. So doesn't seem like there's a whole lot there. So I'm just gonna go right towards the end. Where they're wrapping up and setting things up for tomorrow.
With you about this matter, either in person, electronically, or by any other means. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to...
Oh, I'm sorry. It was a lady witness. I apologize.
In this case, after this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has any reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, we'll see you all tomorrow morning. We'll begin at 8:30. All rise for the jury. Thank you. Be seated. I know, Mr. Brooks, I think you wanted to make a more full record just regarding the timing of that last witness. I'm not going to put all of the details on the record. We made a record in closed session just due to a privacy issue related to that witness, and I required you essentially to call that witness out of the preferred order that you had given her availability. I believe you wanted to put on the record the information you initially had from Attorney Opper was general about her unavailability on Friday, which was the day, as I understand, that you preferred to call her, and more information was provided today. I don't want to get into the specifics, but would that be a fair characterization of kind of the discussion we had outside the presence of the public?
Yeah, that's fair.
Anything you want to add to that?
Nah, just it pretty much sums it up.
Okay, good. So
I felt that it would be, thinking about it as everything was happening so fast, I was just like, yeah, it probably would be best to, take the procedure that she's having into account, because it could be.
I don't want to go into that while we're still in the public record.
Right.
All right, due to her privacy rights. But I appreciate your understanding with that and calling her. I did require you to call her out of order, but I appreciate your understanding and of that. I don't think there's anything else I need to cover at this time, unless there's something from either one of the parties. From the state first.
No, but we would like some further direction from the defendant as to who he wants here tomorrow morning and tomorrow afternoon, if he wants us just to continue that list that he originally provided, or if there's an update. And we could do that off the record, Your Honor. I don't know that we need you involved, but.
Okay, thank you. Then hopefully the parties can figure that out without me needing to be involved further, but anything from you, sir?
No, I'm just gonna say with that, I'm not gonna put them in specific order.
Not looking for the order, but we're behind given the timetable and the understanding between, as I understand it, between you and the state.
State has the list.
So generally speaking, you've been taking about a half an hour, I would say, for each witness. At least that one took about 35 minutes. If we go on that schedule, do you think, understanding we take a mid-morning break, a lunch break, and a mid-afternoon break, I would think we could get through at least 3 to 4 tomorrow morning and 3 to 4 in the afternoon. I'm going to have the parties be available for that and be ready for that. Whatever order, but...
All the parties?
Yes, both you and...
So at this point, there's no telling what witnesses will be here tomorrow, right?
Well, based on the groupings that you gave to the state, it sounds like we got through only one from each...
Right.
Kind of category that, so we'll go back to the first would have been Thursday morning. You need to call the rest of Thursday morning. Was there 2 left of that?
Yes, correct.
So
let's do Thursday morning and Thursday afternoon. The people you designated, I'm going to direct the state to have here tomorrow morning. That's 4 witnesses, whatever order of those 4.
5. It's 5, but yes.
It's 5?
We'll have them here. Based on your original list.
And then... how many does that leave? Because
that's what I'm trying to
doing good with math this late in the day. 4, so 4 in the afternoon then. So our hope is to get through all your witnesses.
I can say this
tomorrow
for the record. One witness I intend to call tomorrow is not going to be 35 minutes.
Fair enough. Do you plan to call that person in the morning or the afternoon?
I'm leaning towards the afternoon. That could change depending on the flow of the morning, I would guess.
Oh my God.
If the morning goes pretty...
Can you tell me which list they were on when you gave it to the state? Was it Thursday afternoon, Friday morning, or Friday afternoon?
I didn't put them on days, but I believe they were in the the second flow of names. If that
Tell
helps.
me who it is so we can prepare so that person is told to come in the afternoon rather than wait through the morning.
I don't want to say who it is.
Why not?
Well, I want the person to be here when we're ready to go, but...
They were here today, if that helps.
Yeah, I know who it is. It's Erica Patterson, Your Honor. There's no mystery here.
Maybe
All right,
it is,
that's
maybe
what I
it isn't.
would have... That's kind of who I thought it would be as well.
So...
I'm going to have her come tomorrow afternoon then.
Okay,
I'm not
we
gonna
will
have her
have
come
you
in the
here at
morning.
1 o'clock tomorrow afternoon.
So we need to be mindful of people's schedules.
Thank you. We'll have everyone else here at
That's
8:30.
interesting because what if that was not who I was referring to?
Then you need to tell me right now so I can make an alteration to that.
Come on, Judge.
Sir,
This isn't a fucking game.
3rd week of trial.
So
I
can we
need
at
to
least
keep
be
this
fair?
moving
Can we at
along.
least be fair and say that's not due to me though?
That would not be fair to say.
How?
It's
how? The state said that they needed 5 to 7 business days to present their case. Did they or did they not say that on the record?
And there's
So how
it doesn't
did
matter how we got there at this point. I'm trying
Then they
my
need to chop,
darndest
chop.
to get all the
Should've been
witnesses
chop, chop.
done. So I'm directing the state to have Miss Patterson come tomorrow afternoon.
If that's
and the
what I
other
was referring
witnesses,
to, which I wasn't, but everybody think they know what I'm thinking.
then you need to
That's it.
tell them that
Then
it's
who is
someone
it?
else. And if you want her here in the morning,
I'll
then
say this. Everybody that was here today that didn't get called, have them here tomorrow. So that'd be 1, 2, 3.
He thinks he's gonna try and call the fucking state again. It sounds like.
And you need to tell me who you want in the morning, not by the order, and who you want for the afternoon. Otherwise, I'm going to make the order that I just made.
No, how you gonna make the order for me?
Under 906.11, sir.
No, you can't. I can call. I have the right to call them in the order that the state didn't have to have an order. And I'm guessing.
No, but the
Correct me
state's
if I'm wrong, but
helping you out in terms of the order.
They were helping me out with serving
And
the
they're helping you.
subpoenas. Not the order of how I would call the witnesses, but the subpoenas. And I gave the state.
Do you want to be responsible for calling each person tonight and telling them what time they need to be here? Or should we let the state do
Here we go
that?
with this again. There's something that's impossible to do.
That's not true. You have
How's it
access
not
to
true?
a phone.
So somebody's gonna answer a collect call from someone they don't even know. Nobody in this courtroom will answer a collect call and pay for a phone call from somebody that
my
you
understanding
not know.
of how it works at the jail. That you can.
Yes.
There's other means to make phone
There
calls.
there is no other way to utilize the phone.
And if only you had an attorney who could do this for you.
The state is helping you out. This is to make tomorrow go as smoothly as possible, to be effective, to be efficient, and to use all of our time wisely.
Your Honor, with all respect, I did what was asked of me to do. I provided them with the list of the witnesses that I will call. And I stated before.
I see that, Risen. Thank you.
Ordered, and the state accepted the list that I gave them. So why, at this point, is
Who are the witnesses who are here today?
Kohler, Douglas Kohler.
Detective Guth, Erica Patterson, Christopher Bertram, and Jason Hayes were here today, in addition to Miss Reimer. Miss Reimer's now done. Nicholas Kirby was also here today. He's done. If we are going to continue to assist Mr. Brooks in getting these witnesses here, we need to have a reasonable time schedule. These
Prosecutors
witnesses
are
don't
done with this
show
shit.
up by the tooth fairy. We
Yeah.
have to communicate with them. They have jobs, they have families. I've explained this 3 times to Mr. Brooks. If he wants our assistance,
Objection. She can chill with all that. She can chill with all that tone.
I know.
Get on that if that's what it is.
See again. Well, he don't like it when a woman has a tone with him.
I know it's been a
Definitely
long
get on
day.
that.
Let's keep this civil.
That's what I'm trying to do, but
So
she gonna have to tone it down.
I think both of the parties are getting a little
For real.
frustrated. I'm getting frustrated. So, Kohler, Guth, Hayes, Patterson. I missed a 5th.
What do you say there in that muttering?
The parties are getting a little
For real.
frustrated. I'm getting frustrated. So, Kohler, Guth, Hayes, Patterson.
I don't know who they be thinking I am. That's what he said. Fucking prick.
I missed a 5th.
Bertram.
Guth is a police officer, right?
Yes.
I know who Eric Patterson is. How about Kohler, Hayes, and Bertram? Are those citizens?
They're citizens that relate to the parade, I believe, and post-parade. Not the DV.
It seems to me that even with one of the witnesses taking more than 35 minutes, that doesn't fill up the whole day. So we need to have some other people on that list for the afternoon.
So I will just continue to work in the order of the list that was provided, Your Honor. I think that's the only reasonable thing we can do at this point, or we can do it alphabetical, or we can do it by random lot, because I don't know really what else to do.
By the list that was given.
What was the order of the list that you were given?
The first 3 were Kirby, Kohler, and Guth. The next line has 3 names: Patterson, Bertram, Hayes. The third line has 3 names: Reimer, Aldrich, and Lescano. The last list has 2 names and then also reads the state of Wisconsin.
First 3 people on the list you need to advise to be here tomorrow at 8:30.
Okay.
The next 2 people tomorrow at 10:30. The next 2 people after that tomorrow at 1:30. the next two people from there at 3:30, and then do I have anyone left over from there?
No,
Yeah.
One more?
no.
If I have to go late tomorrow, then I would say the last person can be at 4:30, if need be.
Yeah, I agree. We would very much like to get through the defense witnesses tomorrow, Your Honor.
I don't know if that's gonna happen.
Well, that's the order that I'm making in terms of the times people need to show up. That gives you a range of people to select from.
I'm gonna have to see that, what you're referring to then, because
Oh, I trust you wrote it down because that's what I did.
I
So
didn't. I
we
didn't
are at
write it down.
recess then for the evening. We'll see everyone tomorrow at 8:30
all right.
a.m.
So
Thank
if they
you,
don't get
everyone.
called like that, don't try to blame it on me.
So yeah, there another day, another shit show. Arisen, you gave me the link to the interview that the I already forgot. I already forgot the poor bastard's name already. But Erica's friend, the ex's friend who was involved there.
Well, first of all, what was it like just being called to testify for Brooks's defense?
Nicholas Kirby, that's it.
Honestly, trying to hold back a lot of rage. Took a lot not to want to jump over the table.
I mean, everybody and their mother could see that you were ready to fucking throttle him across the table.
Is there any doubt in your mind that he's guilty?
He's absolutely 100% guilty, but this delay process that he's trying to do and pick apart scenes bit by bit and fraction by fraction is not going to help him whatsoever.
What do you think? I mean, just based on the questions that he asked you today, what do you think his defense is? It's very unclear at this point.
His defense isn't unclear to me. His defense is delay and confused. That's all he's doing. He's trying to use what was first said to me right after a traumatic event happened, to where at that point, which all my thoughts were jumbled when I was giving my statements to the detectives. You know, I still had a lot of stuff going through my head at that point in time when I was talking to those detectives, and I think he tried to take advantage of that and realized that he couldn't.
When you encountered him by the SUV with Erica and Corey,
Guys, only one thing is working.
for you being in his presence?
No, it wasn't scary for me being in his presence. I've faced guys like him before in my life. I was more worried about Erica. I was more worried about Corey. I never for a second thought that this man would drive down a parade route. All I told him was, you need to leave. The police have been called. You need to get out of here. And like I told Court TV, and like I will tell everyone till the day I die, to everyone who is suffering from this, I feel like this is my fault. Because I told him he needed to leave. I feel like he may have panicked in that moment when it was a very scary moment for him, and when he heard the sirens, he knew law enforcement was coming and he took a wrong direction. But if he ultimately did make that decision to take human life, then that's on him. The regret that I have is that I didn't do something more. I would have put my life in danger and had my life taken in order to save every single one of those people. And that's something I can't do anymore because now he's locked up.
When you said you live downtown, right? So, I mean, this was impactful to you just as a resident of Waukesha.
Yes, it was.
Okay. Well, thank you so much. I appreciate it. Thank you.
Damn. I mean, I can see that. But that's rough. All right, guys. I'm not gonna drag it on for much longer. And I'm just gonna go through the rest of the super chats and we're gonna close it up. Excuse me. There we go. Starting Jemison. There we go. $5. 7 in the video. The lyrics, doesn't he rap about running over people? I think I saw people in chat mentioning that the lyrics of it, the lyrics of his fucking music video actually talks about him running people over, which probably explains why the prosecutors say that if the audio was played, it would be extremely prejudicial against him. So Actually, maybe. Do I have where is it? Copy link. I don't even know. I want to. We want to see that. No, you know what? I don't have subtitles though. I heard it said at the very beginning of the video. Actually, you know what? Fuck it. I can't bring myself to listen to it. Sorry. I'm sorry. Forget it. Forget it. Forget it. We're gonna move on. Becky, thank you for the 223 super chat. Super Saiyan Tantrum Power Go. Z360, thank you for the $1. El Hurricane, thank you for the $5. Been talking to someone who apparently has relatives in the area. The judge is known for being very tough, so you're not seeing who she normally is. That's actually surprising that she can turn it off and on. Wow. Linda Live 72. Thank you for the $4. Thank all of you for re-upping your memberships. Tatted Cat. Thank you for the $5. The Little Snow Trag's opening statement was an insult to the victims and their families and to the police and the people of Waukesha. Could have said it better myself. Janelle, again, thank you very much for the $199.99 super chat. Z360, thank you for re-upping your membership. Barslow, thank you for the $5. And that's about it. Thank you guys. I'm obviously not going to be streaming tomorrow. I'm probably not going to be streaming over the weekend. More than likely not. And so you'll probably won't be seeing me until probably Wednesday evening. So hope you guys have a good one. Why not? What? Danny asks, why not? I mean, you know, I'm going to be on vacation. I mean, I might do an impromptu stream. I mean, I got my phone, but we'll see what happens. I just say that just to like say, don't expect anything like planned ahead of time. You know what? I might actually, if depending on what Friday, how Friday happens, I might do an impromptu stream just to give my thoughts out on what happens tomorrow. But we'll see what happens. All right, thanks guys. Have a good one. The boys are hungry again, so I gotta go feed them. And yeah, take care. Adios. No. Fine.